Today's topic is the breach of fundamental rights constitutional remedies. ꯑꯩꯈꯣꯏꯒꯤ ꯂꯩꯔꯤꯕ fundamental rights ꯁꯦ ꯊꯨꯒꯥꯏꯔꯛꯑꯀꯥꯟꯗ ꯑꯗꯨꯒ ꯑꯩꯈꯣꯏꯒꯤ constitution ꯅ ꯀꯔꯤ ꯀꯔꯤ protect ꯇꯧꯔꯤ ꯀꯔꯤ ꯀꯔꯤ protection ꯄꯤꯔꯤ ꯍꯥꯏꯕꯗꯨꯅꯦ. You may have an idea of the Constitution of India. The Constitution also provides the remedial measures in itself if the fundamental rights are violated against the individuals. Kanagumba ꯑꯩꯈꯣꯏꯒꯤ fundamental rights ꯁꯦ violate ꯇꯧꯔꯛ ꯇꯥꯔꯒꯗꯤ fundamental ꯌꯥꯝ ꯆꯥꯎꯕ major role ꯑꯃꯈꯛ ꯂꯧꯒꯗꯣꯏꯅꯤ. ꯑꯗꯨꯅ while the constitutions of India provides various fundamental rights, it also provides the remedial measures in itself if the fundamental rights are violated against the individuals. The constitution is supreme. Constitution pirakpa decision do that is very powerful. Supremely ꯑꯩꯈꯣꯏꯒꯤ rights ꯁꯤꯡꯁꯦ ꯂꯣꯏꯅ ꯃꯥꯅ control ꯇꯧꯔꯒ ꯉꯥꯛꯑꯒ ꯁꯦꯜꯂꯒ ꯊꯝꯗꯣꯏꯅꯤ custodianꯅꯤ. Then it distributes the power to the executive, judiciary, etc. ꯉꯁꯥꯏꯒꯤ constitution ꯗꯨꯅ power ꯗꯣ ꯁꯤꯁꯤ ꯇꯧꯒꯗꯕꯅꯤ ꯁꯤꯁꯤ ꯂꯧꯈꯠꯄ ꯌꯥꯏ ꯍꯥꯏꯕꯗꯣ executive ꯁꯤꯡꯗ judiciary that means Supreme Court ki leiba, High Court ki leiba judges mayam singse moisine exercise torisini. The legislating power is granted by the constitution to the parliament and also to the state assemblies. Legislating power habidi ain semba ko ain semna ba power sina legislature kanguda haide parliament da aduga state assembly da sinari sineba ada makoina ain semakpa kanda human right violate tauba yaba ain amata semakpadi yaroi ko to ain du semak taragadi madu Supreme Court na madu yingsilakane ba ko magi power exercise tawakane ba ko anasta haise state shall not make any law which takes away or abridges the fundamental rights. Asagi state na law semakpa kanda ko fundamental rights se violate tarpa yaba sohalakpa yaba amata law mata ko semakpa yaroi ko. The constitutional remedy in the first aspect lies in the constitution itself. Constitution na akhoi che nga aga selaga akhoi praja sing se nga aga selaga fundamental rights se phangali have se constitution da mek lan adum iraga adum yorma ni have the constitution remedy na article 32 da mek lana mang dai kuna rich mayama nainagre we have already discussed the what about the rights of the constitution under article 32 we have already discussed. I think you may have idea of that rights also. And article 32 provides that the right to move the Supreme Court by the part 3 in the sense fundamental rights. Constitution ki part 3 se fundamental rights ni. This fundamental rights is the article 32 the make saying na kanagumba fundamental rights se violate tawtaragati court Supreme Court chatlakanda natagna High Court chatlakanda magi fundamental right to amuhana pangaknaba habidi remedial constitutional remedy taroknaba yam chawna dum piri ko aduna Supreme Court shall have power to issue directions or orders of writs tongan ba writ makal mayama Supreme Court na issue tawung ami adudi mamang da suninagre ko ana says the and any law made in contraventions of this clause shall to the extent of the contraventions be avoided. And thus the object of the constitution is to prohibit the state from making a law which either takes away totally or abrogates in part of fundamental rights. The expression the state is to be construed in conformity with Article 12 is judicially interpreted. The constitutional remedy in the first aspect lies in the constitution itself. And constitution di magi part manungduda aikoi gi rights in protect tawnana ba constitutional remedy sudum yaujaraga dum leirabane ko. And another course of the constitutional remedy is provided to the judiciary by the constitution. Article 32 gives the right to the citizens the constitutional remedies. Article 32 provides that the right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by the Part 3 is guaranteed. Further, Article 32 provides that the Supreme Court shall have power to issue directions or orders of writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari, whichever may be appropriate. Haidi tongan-tonganba writ makhang mayamni, order mayamni, akhege fundamental rights ado violate torokpa matamda ado fundamental rights violate torokpagi magi nature sinje khenei nature dugi matungina situation dugi matingina tongan-tonganba writ mayama order torokadoni madugi writuni mana whichever may be appropriate sanaba ma yengkanda ko kaidongna badudi for the enforcement of any of the right conferred by the article Part 3 of the Indian Constitution. The Parliament may by law empower any other court to exercise within the local limits of its jurisdiction. Within the local limits of its jurisdiction, all or any of the powers exercised by the Supreme Court under Article 32. Then in Article 226 gives the High Court the power of the Supreme Court given in Article 32. Then Article 32 provides that the rights guaranteed shall not be suspended except as otherwise provided for by the Constitution. ID Constitution na akhigi fundamental rights mayam sinche protect tawraga thamme karigumba fundamental rights manghal agadi court chatla kanda wakatpa Supreme Court OBI adigi High Court OBI chanaba adigi court chatla kanda court na madugi mayam do tara kanda magi writs mayam order mayama chanaba order mayama pidina magi fundamental right to amuk phangandoini ba ado fundamental rights che phanganba kanda ningjangadaba mana kaiginoda National Emergency President Rule the Doctor Makatamda for the fundamental rights suspend the win among the Yagre. At the high basiki suspend of Bukanda fundamental rights law and suspend of Bra, Taudabra, Karamakadi dum Lehawi and Abisupangre. Ado targadi Karigumba, a fundamental rights Karigumba Mong Matada, a fundamental rights Matpayade, except Magi. Established law haidi matam chana the mari lenaba ain haidi India national emergency gumba president gumba lakpa matam dukak natana fundamental right kharadi suspend tawba khak natana atopadi fundamental right ti amta valid tawba yade ko provides that when the proclamation of emergency is made by the President under Article 352, the freedom guaranteed by Article 19 are automatically suspended and would continue to be so for the period of emergency. Among the emergency, Article 19 gi makha da piriba freedom of movement, freedom of expression, freedom of settle, tongan freedom mayam se Hojiki high national emergency lakpakan president nilauthorpa matam stage national emergency laying manungadi high fundamental rights suspend tawne. Then atopa madamu Article 359 provides the suspensions of the enforcement of the rights conferred by the Part 3 during emergency by the order of the President. Article 359 gi makhada the President rule na stated Tambakando, the fundamental rights, correctly suspend of doing. So, Sigi constitutional remedy, constitutional safeguard to Article 30 to say it is so important. As a fundamental rights, may am the important in the law, the Kaiginoda. Tongan ba, the constitution maker sing, tongan ba experts in the shoe, what paper kanda, Article 32 sina hena, sukimatic important way di kaignoda, ꯑꯩꯈꯣꯏꯒꯤ ꯃꯃꯥꯡꯗ ꯂꯩꯕ articles ꯃꯌꯥꯝꯁꯤꯡꯁꯦ fundamental rights ꯃꯌꯥꯝꯁꯤꯡꯁꯦ violate ꯇꯧꯔꯛꯄ ꯃꯇꯝꯗ article 32 ꯁꯤꯅ remedy ꯑꯣꯏꯅ ꯍꯥꯏꯗꯤ ꯃꯗꯨ violate ꯇꯧꯕꯗꯣ ꯃꯥꯒꯤ right ꯇꯣ ꯍꯟꯖꯤꯟꯅꯅꯕꯒꯤꯗꯃꯛꯇ ꯍꯣꯠꯅꯕ ꯀꯥꯟꯗ article 32 ꯗ ꯃꯌꯦꯛ ꯂꯥꯅ ꯄꯤꯔꯒ ꯂꯩꯔꯤ ꯑꯗꯨ ꯗꯥꯛꯇꯔ ꯑꯝꯕꯦꯗꯀꯔꯅ ꯀꯩ ꯍꯥꯏꯔꯝꯃꯤ ꯌꯥꯝ ꯆꯨꯝꯅ ꯍꯥꯏꯔꯝꯃꯤ ꯑꯗꯨꯗꯤ if I was asked to name any particular article in the constitution as the most important, an article without which this constitution would be a nullity, I could not refer to any other except this one article 32. ꯍꯥꯏꯗꯤ article 32 ꯁꯤ ꯌꯥꯎꯗ꯭ꯔꯒꯗꯤ constitution ꯁꯦ ꯃꯌꯦꯛ ꯏꯁꯦꯡ ꯁꯦꯡꯗꯕ ꯑꯗꯨ constitution ꯁꯤꯗꯩꯁꯤꯗ fundamental right ꯀꯤ ꯃꯇꯥꯡ ꯅꯩꯅꯔꯛꯄ ꯀꯥꯟꯗ article 32 ꯁꯤꯅ ꯌꯥꯝ ꯆꯥꯎꯕ safeguard ꯑꯃ ꯄꯤꯔꯤꯕꯅꯤꯅ ꯃꯁꯤꯒꯤ article 32 ꯁꯤꯅꯤ ꯗꯥꯛꯇꯔ ꯑꯝꯕꯦꯗꯀꯔꯅ ꯑꯁꯨꯛꯀꯤ ꯃꯇꯤꯛ ꯃꯔꯨ ꯑꯣꯏꯅ ꯍꯥꯏꯗꯤ ꯃꯁꯤ ꯌꯥꯎꯗ꯭ꯔꯒꯗꯤ ꯃꯤꯑꯣꯏꯕꯁꯦ fundamental right ꯁꯦ ꯃꯇꯤꯛ ꯆꯥꯅ ꯃꯄꯨꯡ ꯐꯥꯅ ꯐꯪꯕ ꯉꯝꯃꯣꯏꯗꯕ ꯑꯗꯨꯅ article 32 ꯁꯦ ꯃꯥꯅꯁꯨ ꯌꯥꯝ ꯂꯨꯅ ꯄꯜꯂꯝꯃꯦꯕꯀꯣ it is the very soul of the constitution and the very heart of it constitution ge soul ni bo haiziko so in the next part then under article 32 and article 2 to 6 any person who feels breach of fundamental rights can move to the relevant court article 32 shina haibi hojiki constitutional remedies na fundamental rights violate tawtagadi supreme court na high court chatpa yagani na hai sida article 2 to 6 ina maroina state high court ka mari leinaba powers ni adidi on the text of the article 32 and article 2 to 6 where the fundamental rights is involved a party should be free to approach either the supreme court or high court supreme court high court notwithstanding the above positions the supreme court held that where the relief through high court is available under article 2 to 6 the party should approach the high court high court chatpa yabagi room later the article 2 to 6 se sima khada high court chatkadabani haba supreme court is protector and the guarantor of fundamental rights and supreme court se aikoigi protect tawrakanda aikoigi custodian ni aikoigi fundamental rights se mana senaraga leirini violated tawrakada mana yengjangadoni ko and by article 32 the supreme court has been constituted as a protector and the guarantor fundamental rights conferred by part 3 once a citizen has shown that there is infringement of these fundamental rights the court cannot refuse to entertain petitions seeking enforcement of fundamental rights as held by supreme court is witnessed in various judgment among the judgment mayam supreme court na pigiba judgment mayam maduna khange magidi kainada kanagumba mana magi right se violate tawire supreme court move torpa kanda madu lawdaba sunga yadeba tangai fadana madu maramdu yen kana yam thuna magi fundamental rights to anganna ba hotnagadabane the supreme court took it as its solemn duty to protect the fundamental rights zealously and vigilantly tangai fadana tawdaba yadaba amoina supreme court lawkhatkani ko ado sigi matang sesta yam maru oina hojik manipur da thokpa case khara example oina nainaraga yengse see this picture coverda ngasi nomani ki mamangda adum iraga adum laiba ko Irendrop book under NSA National Security Act for his criticism of BJP leaders on use of cow dung and cow urine as cures of COVID-19 nene kay matam na taramani mamangda Facebook ta irubagi ko ngasaygi sangi amangba adagidi sangi mayungna urine pahalle ye kanaga kanna inabagi adagidi TV daga so adagidi Facebook ki ka video clip oina suna yam uba pangamani khalle mapan gilamda sangi mayung adagidi sangi mathi dorkanda covid na dana bani kana kano tawba orthodox oiba haitare ko adumain tawduna ngasagi irendrona ogi government so adagidi usitaba de kano tawdaba yawi haidina mase pick up torkana fara kanda jail da namjangi ko ado sidani nasagi karai wa deno sigi context pala ise hakanda fundamental rights aduga sagi article 32 se kama seasonal cases da yengo ko adi aigi freedom of speech ni aigi freedom of expression ni haina mamang da su fundamental right ne na bakan da su yawre aigi freedom of speech tuna karigumba kano atopagi fundamental right sokal agadi hurt or agadi madu magi freedom of speech to limitation to wang malala agadi ain necessary action local ko yai adigi amusu argumental lere ma aina local ka iba aigi freedom of speech na atopada sokhande sokhali habigi argument ni lakrishi ko ana sida Irondro, who was detained under National Security Act over remarks pertaining to the death of the BJP State Chief S. Tikendra Singh due to COVID-19. Following Singh's death, Irondro had written on Facebook, "The cure of corona is not cow dung and cow urine. The cure is science and common sense." Professor G. R.I.P. European presidential laikidaba kanda mana khitang magi iriba londas ju khara migi laitabagi kanna nungaitaba kano tawrinida irubasda ja jam chawna su miyamna su hafet kaino man toisibon khanna giba tanja ama khakni mana iriba londa do chumba chumdabna tokthokrakanda kanaguma laitabagi migi kanna kano tawrini tanja ta igibado ko adu wani aduna stage da yam nungari di ko man like itabagi sigi kano se tawbakan sesta ma se kota complaint tarokna complaint kanan tore edude a case was registered against him on a complaint filed by Usam Deven Singh, Vice President of BJP's Manipur unit. The complaint said his Facebook post had deliberately and willfully insulted and outraged religious feelings and sentiments of BJP workers and the family members of the deceased. Masagi man eba stage da deliberately ko hadi atamnana yamna usithoy daba man ba willfully insulted ka ko and outraged religious feelings. Masagi Hindu gi adagi adugi kana khara kano tawraga irakpagi mawong aduga ngasagi BJP gi workers singda aduga laigidra imung sigi kanoda sokan bayaba warolni na tarkanda complaint ama file tarkanda case tarkanda mase agi bane ko ado sigi matang says da bayab di kedoi it may be mentioned that the Supreme Court directed release of the political activist book under NSA for his criticism of BJP leaders on use of cow dung and cow urine as cures of COVID-19, saying he cannot be put in jail for even a night. Oh, adi maase jail gi thado kona BJP gi kano se case tawna matungda magi freedom of speech magi kano sina sokhande sokhali ni case tawra kanda ko thado kona maase handakta kui dina right tarakhi ko. It was on 19 July 2021, following the directions of the Supreme Court. The state government has released political activist Irondro, who was booked under NSA for his criticism of BJP leader on social media. The Supreme Court na thadok tabay yade na masagi state government ta thadok na naba harak padigi mase nan Monday 19 July gi harang hani ko adedi da mase jail dagi thadu eba jail dagi thadu ko photo duni sida hojik laise jail dagi thadu ko aduga mase amuk makata na yengba yare di kaidobagi no argument da kamaina amuk kano hage do yengsi Supreme Court na kay hage da ko a bench of Justice D.Y. Chandrachud and Mr. M.R. Saha said that his continued detentions will be in violation of his fundamental rights to life under Article 21 of the Constitution. Kay mama se jail da phajil laga thamtaragadi hojik piriba Article 21 da magi freedom mayam piriba the right to life kan piriba mayam se masi violate tawgadore aduna mase detain tawbayade. The top court directed that the order be immediately communicated to the Manipur jail authorities to enable his release by 5 p.m. on Monday itself. Nidokaba numitugi kung manga ta matam na mase namnang thadukadabani madu thadukata gadi mase jail thamjan bata gadi mi fundamental right to violate tawre na court na minus Supreme Court na right ta ko jahari se Article 32 Constitutional Remedy duni ko sesina kanda Iren rogi mapasina Supreme Court chatla kanda case file tawri neba nina khanga dabdi hawjin na discussions ko. The statement was made in the context of the death of the president of the Manipur BJP due to COVID-19 is a criticism of the unscientific positions taken and the misinformation being spread by several BJP politicians regarding cow urine and the cow dung being effective in preventing treating COVID-19. Kaino the mamang BJP gi kanosing na su members in the Suhaitare, Sandokba Mayama Leva, Kaugi urina, the Kaugi dung, COVID-19, Sangande, COVID-19 file, Canada, Sandoku Mayam Leva, Junamara Motaka, or Kanda Irin Rosna, Facebook the Irubani is in what you can know is in arguments now. Argue that the present case is a shocking instance of misuse of preventive detention law to stifle completely innocent speech that is fully constitutional protected and was made in public interest. Eno nangango ido masagi miyamgi public interest yenga kanda adigi constitutional people right to mangonda chapchana lay maduna kanagumba matada madu shokhande na court na argument or inevitable. Aduna sidashida the court order stated kaya having prima facie considered the contents of the petition, we are of the view that the continued detentions of the petitioners before this court would amount to a violation of the right to life and personal liberty under Article 21 of the Constitution. Masagi petition haidi magi mapana defend taunana ba tharakpa kanado wiki case to ko adugi case to mun yengor kanda hojike hairiba misakse victim moiriba misakse court sum laitaragadi magi article 21 right to life pangoi dore right to life se sohalle anamtal right to violate tawre aduna masi yade haba aduna we accordingly direct the petitioner shall be released as forthwith a rikudakta forthwith as in the by way of an interim direction of this court unless he is required to be in custody in any other case. Hadi atopa case ka mari lena taragadi na kudakta thado kidongni subject to further order subject to his filing a personal release bond in amount of ₹1,000. Ade sida natana ma thado pa kanal pa lising namagi bond ibana igadawni haba adon sida natana amuka main tawidudi mana detention tawraga lairuba mana hoide pharaga lairuba se masigi compensation masigi kheti puron haitare maram charuna phajalamme habigi sen compensation hangadabani government da madu hangadabani magi case to sokna bakam changyu pesado ndokadabani habigi bawa rai bawa jike haiba Supreme Court na piude yaw Supreme Court na human rights se protect kaunabagi da makta Article 32 gi makhada and chauna the constitutional remedy se masi nga ga selaga thammi habise ko government chu magi kanodo magi chu tawam thokpa ko age ko freedom se magi freedom of expression freedom of speech se sijina bada kai gumba limit to wang malala gadi government chu tawam thokpa dum tor ko deba ado adai da amuk victim orijuna aina ngangi da sokhani ngai leite aduga ai kana mamta da ka pi gi dena ma su muk to banga magadi court chala kan muk tor ko dine ko aduna admai tawduna ngasagi tongan ba akoigi ano singse fundamental right singse da piraga fundamental right man se ko piraga lay adugi sigi pira fundamental right se ko na khang da taraga di aduna sina ba haite taraga di akoigi right se phangdana lay joine ko aduna aikogi right se phajana mapum phana pangnana ba aikoina fundamental rights tammiba akhoi human right hai tare not only human right fundamental rights atop subject sum yaugni ko masi mapung phana fajana khang taragadi nungai doine ba